Pankaj is not on camera.
Camera is on. You're not able to see.
Okay, now I can see. Okay, I think something. Yeah. Good afternoon and a very warm welcome to all the participants. The Reserve Bank of India had recently published new regulations on overseas investments. The government had come out with the draft FEMA regulations on overseas investments for public consultation in August 21. After evaluating the feedback from the stakeholders, the new regulations were announced with effect from 22nd August 22. Primarily, these contain some welcome changes, providing clarity on some issues and also liberalizing some restrictions on investments outside India by Indian companies and Indian residents. I'll just highlight some of the significant changes announced by RBI. Firstly, some key terms like control, strategic sector, overseas portfolio investment, overseas investment, net worth, etc., have been clearly defined. This will definitely reduce disputes on interpretation in individual cases. Then overseas investment has now been clearly demarcated into overseas direct investment or ODI and overseas portfolio investment OPI. Basically, ODI up to 400% of net worth of the investor is permitted for investment in unlisted equity capital, where the investment is more than 10% of the capital of the foreign entity, or the Indian entity has control over the foreign entity. OPI, on the other hand, permits investment up to 50% of the net worth of the investor for investment in foreign securities other than unlisted debt instruments, derivatives, commodities, including bullion. Some gray areas have emerged from this, which we'll debate with our esteemed panelists today. An interesting clarification here is for investments made by resident individuals. ODI or OPI by resident individuals is allowed subject to the overall limits as per LRS. But ODI is permitted only in operating foreign entities with control, which is not engaged in the financial services sector and does not have a subsidiary or a step-down subsidiary. Further, it is provided that gift of foreign securities from non-resident relatives is allowed without any limit, and non-relatives is allowed subject to FCRA. Acquisition of foreign shares as per uniform ESOP or EBS scheme is also covered under the LRS limit. This is a delicate change which will require some inputs from our panelists. In a major departure from the existing normal, RBI has now permitted round tripping, provided the structure does not result in two layers of subsidiaries, of more than two layers in subsidiaries. This is an extremely significant change, and there are a lot of questions which have arisen requiring clarification. Another major change is in the financial services sector. Now, Indian entities not engaged in the financial services sector and having a 3-year profit track record can also make ODI in the FS sector other than banking or insurance sector. And then to further promote your IFSC or GIFT City, general permission has been granted for investments in an entity located in the IFSC as per the ODI or OPI regulations. There are a few other changes, but two changes having significance are A, the deferred payment for overseas investment is now permitted without approval, and B, swap of securities in transactions is now permitted as against only swap of shares under the erstwhile regulations. So now, without taking any more time, let me now introduce our most knowledgeable panelists. We have R. Sridhar, a company secretary and lawyer by profession, with over 24 years post-qualification experience in tax and regulatory matters. A significant part of his career was spent in Delhi, where he gained expertise in dealing with complex and varied tax regulatory matters for multinational corporations. He shifted to Chennai in 2006, and prior to joining the firm, ran a boutique consulting firm which specialized in regulatory, tax, and M&A functions. Sridhar is a tax partner in Grant Thornton LLP and is also responsible for the transaction tax practice of the firm for South India. Sridhar has extensively worked on planning and execution of large investments in India in special economic zones, free trade zones, IT parks, etc., and has helped structure foreign direct investment across sectors to achieve tax efficiency combined with regulatory compliance. He has advised both inbound and outbound investments for multiple businesses. Sridhar is a regular speaker at forums across India, including ICAI, ICSI, and various trade professional bodies, where he speaks on foreign direct investment policy, exchange control law, real estate, SEZs, and income tax law. He has contributed to policy making on the special economic zone laws across state and central government agencies. He is also author of a book on exchange control law in India, published by Bloomsbury. Next, we have Pankaj Kodaskar, a chartered accountant with over 20 years of experience in corporate and international tax, business restructuring, including mergers and acquisitions, and regulatory matters such as company law, exchange control regulations. He has advised both domestic and international clients in establishing business presence in India and outside India. He is a member of the Direct Tax Committee of the Western India Regional Council of the Institute of Chartered Accountants of India and a member of the Advisory Board of Basel Area India Innovation Board. Pankaj has been regularly contributing articles in tax magazines. I am Riaz Singna, the moderator for this session, and again, a chartered accountant with more than 3 decades in the profession. And I'm also leading the professional standards for non-audit practice in Grant Thornton Bharat LLP. A warm welcome to all the panelists. And without much ado, now let me start with the questions, because there's a lot to be covered today. So Sridhar, let me start with you. Under the new ODI regulations, round tripping is permitted, provided the resultant structure is limited to 2 layers of subsidiaries. Now, what is the meaning of this 2 layers? There's no clarity on this. What is your view on this change? Does one look at subsidiaries in India only, or in India and overseas for the purpose?
Firstly, good afternoon, everyone, and thank you, Riaz, for the kind introduction, and thank you for having me on this panel. As you rightly said, this is perhaps one of the most significant changes that have come through in the new ODI rules, especially so because the stance of RBI in permitting round-trip structures prior to this amendment was completely different in viewpoint. And as you know, the erstwhile ODI regulations had, through an FAQ, clarified that round-tripping of investments would be permitted only with RBI approval. And in practice, we had seen that investors who were wanting to acquire structures which had Indian arms would fall in line typically by making sure that they acquire the Indian target directly rather than through an overseas holding company. So to that extent, a significant move by RBI to consider such structures in the first place. Now, coming to the fine print of the change. First, I think we should also acknowledge the fact that RBI is now open to payment of value to a multi-layered structure with an Indian arm, where the non-resident seller is able to realize that value fully overseas. That in itself is one big change. But now if you look at some of the ambiguities, and I think pointedly you've asked that question on 2 layers. Now, if you see that the term subsidiary is now a defined term under ODI regulations. And the way it is defined now is different from the understanding that we typically have under company law in India or anywhere in the world. And therefore, to the extent that if a person were to hold more than 10% voting rights in a step-down entity, the foreign entity is deemed to have had control in such an entity. And by virtue of such control, with a 10% voting right, whether individually or in concert with others, it seems like the term subsidiary would then include such a situation. The restriction applies to a person resident in India, which means it includes corporates and individuals as well. It also uses the term financial commitment. So financial commitment is a measurement of investments made by a person resident in India under the ODI window into a foreign entity. And again, the term foreign entity is also defined to mean an entity formed or incorporated outside India. So to that extent, while I've put out all the definitions that are relevant here, maybe if we can put out the slide that we have on the structure, that will kind of bring out what we are trying to say here. So what this practically means is that even a 10% or more downstream investment is to be taken into account for calculating the number of layers. That's the first thing. The second thing is the counting of layers should logically start from the foreign entity downwards, as the term subsidiary means an entity in which the foreign entity has control. So it seems like the first layer from ICO into FCO 1 in this example seems to be disregarded for the purposes of counting the number of layers. Now, there is also ambiguity in the way this is worded, Riaz. And the problem is that the Rule 19, Sub-Rule 3, which uses the term, has said that it should not result in a structure with more than 2 layers of subsidiaries. Now, what results in in more than 2 layers includes the financial commitment itself as well by inference. And therefore, there is definitely a view that is possible that the Indian company's financial commitment into the FCO itself should also be taken into account in counting the number of layers. So in this example, if you see ICO's financial commitment in FCO 1 having a downstream step down in FCO 2, which has an Indian arm in ICO 2, would not be compliant if we were to read the latter into the understanding, whereas it would be compliant if we were to read the former view in compliance. There's also a dichotomy or non-clarity on whether the layers should be seen for companies under India as well, which means in the second on the right hand side of the slide, as you see, while we are compliant overseas, we are still non-compliant in the number of layers because ICO 1 has a step down subsidiary under it, which is ICO 2. And given the fact that the threshold is a 10% threshold, this is a fairly difficult answer to give if we were to measure all of the investments beyond 10% in a structure. Of course, note that this rule of 2 layers is tested only for India, and if this was not in India and outside India, the number of layers are not, at least not operational company layers, are not tested. You have to follow the rules of the home country, certainly. There's also a controversy of zigzag structures. So for example, if in this structure, if ICO 2 on the left hand side also had a overseas investment arm into another FCO 3, how would you read that is still requiring some clarity. But the way, at least conservatively, if one were to read this, the original investment from ICO 1 would get trigger the 2-layer limitation and therefore not permit a zigzag structure as well.
So now, if you were to restrict it to only the foreign subsidiaries, even then it would be crossing the limit. Yes.
Yes, absolutely, Riaz. So even the foreign companies would then also get caught by this mischief. Now, if you were to also extrapolate the taxman's lens or taxman's view in this, perhaps the 2-layer measurement was logical to be measured from India itself, because what it would then mean is that a capital gain event on whether a disposal happens at FCO level or at ICO level would result in a tax liability in India. So if this was a taxman's draft, it would have meant that we would have been limited to looking at 2 layers for the overall structure. And perhaps that's the most conservative view that prevails at this point in time, but certainly requires attention of the Reserve Bank of India to clarify their intent as well.
No, well put, Sridhar. So I understand that even different ADs, bankers are taking different views. So there is a lot of confusion. I think Reserve Bank will have to come up with a clarification pretty soon on this. So on one hand, while this would really, make it easy for a lot of transactions, global business scenario, there needs to be a clarification to avoid confusion in future. Thanks for that, Sridhar. Pankaj, do you think this round tripping would be permitted for resident individuals also?
Firstly, thanks, Riaz, for the kind introduction. And as regards round tripping by the resident individuals, if you look at the rules, it refers to the person resident in India. So it may be possible for the resident individuals to invest in a structure which has a round trip resultant structure, so long as it is within the 4 corners of the permitted regulatory framework.
Oh, great, great.
Yeah, if
Yeah.
I can also add, Riaz, that
Sure.
see, obviously there is a distinction for resident individuals with two distinct windows as well. The first one being ODI and the second one being portfolio investment. The biggest threshold there seems to be that if you are more than 10% in an investee company, you are likely to be measured under the ODI regime for individuals. And howsoever you acquire the shares, whether through ESOPs or through sweat equity or as a direct investment overseas, you would then be stuck with the mischief of not being allowed to acquire a non-operating company anywhere in the world. So to that extent, ODI for individuals has a significant limitation in the understanding. But if it is beyond 10, if it is within 10%, there seems to be a lot of possibility to structure that acquisition without tripping on the round trip limitation. Of course, overall, as a person resident in India, the rule still applies, and therefore 2 layers is something that is sacrosanct in all situations.
But in the OPI, in any case, it would not be permitted.
Yeah,
because
absolutely.
financial
Yeah,
commitment is not
totally,
involved.
totally.
Yeah.
Because it's portfolio, it doesn't measure you for any further downstream investments. And because your portfolio investor, what the investee does further is not in your control. And that's how RBI has not put fretters on OPI investments at any level in any investment by a resident individual.
Great. Coming to the next item, Sridhar, how the new overseas investment rules opened avenues for investing in IFSC? We said that IFSC is being further promoted. So how do these investment rules relax?
Yeah. So Riaz, I guess IFSC has been the flavor of the government's focus. I can't say that it has been the flavor for investors and for other residents, but government is certainly promoting IFSCs. And in that direction, the ODI rules also have put out a fairly reasonable and big big relaxation on account of the fact that they have brought out a separate chapter. The Schedule 5 now defines what investments into an IFSC can be done on the basis of. So a few things that have history. So in the earlier regulations, investments in the financial services sector were subject to approval of the regulator, and there were conditions attached. The first one being you had to have a 3-year profit track record, and the second one being that you must be a regulated entity in India itself. And therefore, the move generally for investments in the financial services sector, whether in IFSC or outside, is certainly a big relaxation and a welcome move. But coming to investments in IFSC, a few things need to be made clear. The first is all investments into IFSCs by residents are treated as overseas investments. So that is very clear. It's either ODI or OPI. That is direct investments or portfolio investments. Now, again, these are specifically covered in Schedule 5 of the overseas investment rules. An Indian entity that is engaged in the financial services sector can also invest in the IFSC with the approval of the regulator in India, and such approval is deemed to have been provided within a 45-day time frame. So ease of doing business for financial services sector in this part has been taken care of with a deemed approval clause. The 3-year net profit track record is not required for an Indian entity in the non-financial services sector. And it seems like the intention is to allow non-financial services sector investors to also use this window to invest into financial services in the IFSC. Of course, the 400% limit of net worth still applies. So if you've not got a track record, but you still have profits, net worth to be able to invest, in those situations, you can certainly do this. But there are some gaps here, and I'd like to highlight some of these as well. The first is that how do you read this if an Indian company wants to set up only a branch office in the IFSC?
Yes, yes.
And how does the rule apply for branches considered, whether the branch is considered as an entity outside India? Would rules on overseas investment apply, or would we have to cover this separately? That is one. The other question
by
is,
itself, I'm sorry to interrupt, but by itself, a branch would be an extension of the head office, may not be considered as a separate entity at all, right?
Absolutely, Ria. So then how do you measure or regulate that investment? Because the branch has to be funded in some manner. Of course, under current rules, a branch overseas is anyway unregulated to the extent of allowing up to 25% of the company's profits to be used for setting up. So is that measure still applicable to an IFSC branch is the question, which needs some clarity. The linked question is also on the FDI side, which means that if you are an Indian company which is in the IFSC, how do you measure FDI rules? Of course, there is some clarity that IFSC is still considered to be within India for FDI to apply, but conditions around pricing or transfer of shares, etc., given the focus on IFSC, a non-resident should not be measured on those if he were to invest in a purely IFSC company. That's food for thought for government to consider in the future as well. Also, investments by an IFSC registered entity back into India would constitute FDI. And by that logic, it would mean that the round trip provisions would also apply. And to that extent, we have to measure both FDI as well as ODI for something like this, fairly complex regulated framework for investors to consider. But yes, it is possible with the two-tier limitation also kicking in. That seems to be the predominant reading. Also,
no,
the fact
good you're pointing out. I'm sorry again to interrupt. So there is a dichotomy here that the first part would be an overseas investment if you have an entity. FDI, it would not be considered as an FDI if it is being if an investment is being made by an IFSC based company. So that two-layered structure may not actually exist in except in theory.
So the problem seems to be that both rules seem to apply, Riaz, and there needs to be a clarity, because we could kind of debate this out, but certainly RBI needs to clarify that if both ODI and FDI rules were to apply to an IFSC regime, are we measuring this in a much more stricter way than what the government intended? So that's more intention, but that's really what it seems like today.
Yeah. Great. And anything that when you invest in funds outside India, then whether that would also trigger the ODI review?
That is, Riaz, it seems like some of the family offices which were non-financial services businesses in India could kind of see this to be a flexible regime to set up a fund in the IFSC regime, and then have co-investors, whether non-resident or resident, coming into such a fund. Of course, subject to FDI and ODI policy playing out, but that is a possibility in the current scheme of things. Of course, this also means the resident family office is free to consider any other overseas jurisdiction as well, and not just the IFSC.
Right.
But IFSC being an Indian company and an Indian resident by tax definition would certainly look better in structure from a tax perspective as well.
Thank you. Now, Pankaj, coming to you, I'll like to digress a little bit out from ODI and actually moving a little bit into LRS. Because recently there have been some newspaper articles which have been highlighting that unutilized funds of of an individual which have been taken out in LRS need to be brought back into India within 180 days. Now, those articles even mention that therefore Indian resident may not even invest such funds into fixed deposits. Now, where does this come from, and what are your views on this?
Yes, under liberalized remittance scheme, a resident individual was allowed to remit money overseas to open a bank account in a foreign bank, including a fixed deposit. And in fact, FAQs issued by RBI has also clarified that one can retain the interest on such fixed deposits abroad and use it as and when required. Now, after the amendment, the meaning assigned to the term OPI restricts any investment in an unlisted debt instruments. And that's probably the reason coming that even the going forward deposits by way of fixed deposits or term deposits in a foreign bank may not be a permitted mode of investment. Now, this seems to be a very narrow interpretation of the legislation, and of course will require clarity from RBI going forward. If you look at the Rule 5 of overseas investment rules that defines what constitute debt instrument, the list does not include fixed deposits. On the other hand, fixed deposits are also not part of the equity investments. So the intention maybe was to just to restrict the such investment using the LRS to limit investments into corporate deposits and not really the bank deposits. However, the way the entire rules have been structured, this does not coming out very clearly and leaving it open for interpretation. While the new overseas regulations were announced, simultaneous amendment was also made to the liberalized remittance scheme to make it or to align it to the overseas investment regulations. Another amendment which has been brought under the LRS regulation requires any resident individual remitting money using LRS window and to repair that money or bring back the foreign exchange into the country if that money is not deployed for the purpose for which it was remitted within 180 days. Now, this requirement of bringing back money within 180 days seems to be creating an issue, especially where some resident individual is trying to remit money over a period of years and park it to buy, say, like a house, and he may not necessarily will be able to use within that 180 days time frame.
Which is very important because they can't, I mean, one cannot take a loan for a house there as an Indian resident. So it's very important that maybe, transferring funds over a period of time and buying a house may take about 3 years, 4 years, we don't know. Yeah.
Precisely, Riaz, and that's where the many high net worth individuals may find it difficult to remit money and park it till they actually put to ultimate use, and definitely a clarification is required on this aspect from RBI.
So the crux of the problem, as I see it, what you've been explaining, is that whether FDs are considered as debt instruments or not. That is the biggest challenge.
Exactly.
But, if at all these narrow interpretations come in, I don't know how the overall LRS limit of 250,000 will work. What will be included, what will not be included. It will be a nightmare to actually look at it.
Yeah, that is an elephant in the room, Riaz, honestly.
Yeah.
Because if I have not used the funds within a 180-day period, or if I have realized something that I sold and just parked the money into a savings bank account or even an FD account, it seems like the intention is if we cross or are within or exceed 180 days, it will come back. If it comes back, then it means I reset the limit for remittance again, and this will again go back into my 250,000 limit for that year. That may not have been the intention, but it looks to be mischievous.
Yeah. Okay, so then, Sridhar, again, coming to the next point. So, overseas investment in the form of debt is allowed subject to there being control in the overseas entity, and the interest is charged at arm's length price. However, the gray area in this seems to be that what is the stand on instruments like redeemable preference shares? These are on one hand considered as a debt, but whether coupon rate also needs to be charged at market rates to these regulations, though they only speak about interest.
Yeah, Riaz, again, so this is it's a important change because under the old regulations, there are 2-3 things here. One is that the requirement to hold more than 10% equity in an overseas entity to be able to provide a loan or a guarantee itself was not there. So I could have had very nominal equity investment and would still have been able to give out a loan or a guarantee to the overseas entity. Now with the 10% control threshold, obviously 10% is a minimum requirement there. That is one. The second is also on classification, because the fact that the moment we have classified or RBI has taken a stand to classify debt and non-debt instruments for ODI purposes, we will need to fit into that classification. Because of which instruments like redeemable preference shares, which were earlier considered as equity instruments or investments in themselves, would then get classified as debt for this purpose. So it is potentially a limiting factor also for Indian companies to invest abroad with a free choice of instruments.
What about existing agreements?
That is also very difficult to answer there, because grandfathering would logically kick in, and the way the current regulations are worded, whatever was done under the previous regulation to be within the law should be grandfathered and therefore not be subjected to further scrutiny. That's really how the position should read out as at a high level, Riaz. The second one being that transfers between holding subsidiary companies were always provided. So interest-free loan was always, there was issues in transfer pricing or tax, but otherwise from a regulatory perspective, there was never a hindrance here. But now with the current set of regulations, there is an expectation to charge coupon rate, arm's length coupon rate. And this is now a question on whether dividend income would also be needed to be transfer price. Pankaj, your views on how you read this?
Yes, Sridhar, I agree. And see, dividend of preference shares, it is not mandatory to pay dividends in case the inadequacy of the profit or absence of profits in the hands of the company. Now, going by this new requirement, whether FEMA still wants or mandates a company to pay the dividend. Secondly, the practical difficulty, that is how one can benchmark the rate of dividend for the transfer pricing purposes, just to meet the arm's length pricing under the overseas investment regulation. In real life situation, we are seen many cases where typically in such arrangements, coupon rate is kept on a lower side, and the investor is compensated by way of a premium on redemption. So at the moment, there is no answer available on this type of arrangements, and that's where RBI will have to come out with the clarifications on these aspects. Another important issue, as you mentioned earlier, all the existing investments have been grandfathered under the new regulations. Now, whether someone has already invested few years back with the low coupon rate and maybe a high premium type of arrangement, how do the companies or the investor will take care just in case to meet the investment or bring the investment in line with the current regulations? It's going to be a difficult situation.
No, I think it's extremely important, all these points that you've raised, because otherwise, in the absence of clarification, all the leveraging models will have to change in all investments that happen outside India. Great. So, Pankaj, while we are still on you, we can also check out that under the new rules, the term OPI has been specifically defined, which is simple, where investment is less than 10%. Any thoughts on this clarity provided by the RBI?
It is a welcome move by RBI that they have categorically defined what constitutes an OPI. This will help us to settle the ambiguities and diverse views taken by AD banks or RBI for that matter. Although the rationale for keeping the threshold at 10% is not very clear. And the only logical reasoning could come out of the non-debt instruments regulation, where the threshold of 10% has been mentioned.
Sure, yeah, I think why 10% and why not 20, why not 49? I mean, that's it.
Yeah,
Absolutely. Sridhar, now with separate thresholds for ODI and OPI investments, does it create some sort of confusion on this in calculating the net worth of the investor?
Yeah, absolutely, Riaz. So, and particularly so for corporate or non-individual investors, because there is now a separate distinct window for corporate investors to also invest up to 50% of their net worth in under the OPI window. So how do you read this when an Indian corporate investor has an ODI as well as an OPI? So is it 400 plus 50, or is it 400 less 50, or is it an aggregate within 400? That is not yet clarified. I would think RBI necessarily should clarify this. Otherwise, the limits in themselves, as we read it, seem to be independent of each other. They don't seem to be talking to each other.
Absolutely. Great. So now, individual investors are permitted to make overseas investment, where an investee entity is an operating entity, not in the FS sector, and does not have subsidiaries. So, Sridhar, do you see any challenge for HNI investors who are often seen investing using the venture capital route?
Yeah, so again, Riaz, an important restriction that is crept in under Schedule 3, which governs investments by resident individuals, is the fact that ODI is permitted in operating entities not engaged in financial services activities. And obviously, there can't be any further step-down investments as well. Now, what it means is a resident individual, if he were to be a sponsor of an overseas fund and they cross the 10% threshold, in that situation, a limitation on the financial services sector would kick in, in such a investment. And therefore, an individual in his own individual capacity may be restricted from investing in such a financial services sector as a sponsor or as the anchor of that investment of that fund or of that financial services entity. But if he were to be compensated under an ESOP plan or a sweat equity plan, while these are, even though they can go beyond 10%, and there seems to be a reading that the financial services sector limitation may not apply because he has earned this under a stock option or a sweat equity plan window, but he would still be governed by the 250,000 limit in all situations. So a bit complex in the way it is reading today. It seems like if a HNI was getting stock options or sweat equity by any chance in a financial services business, and if that were to take him beyond 10%, it would still be part of ODI, which is permitted because there's been no remittance from India or we haven't used. So there's a different understanding there. We need to get clarity from Reserve Bank on this part as well.
Great, thanks, Sridhar. Pankaj, now the RBI, another major move has been just permitted deferred payments subject to the period of deferment being determined upfront and with adequate documentation. How do you see this move?
This is another very welcome change in the regulation, I would say, where RBI has allowed the deferred payment for both issue as well as transfer of securities. The period of deferment, though it needs to be decided upfront, nothing has been prescribed in the regulations, and necessarily it has to be agreed between the investor and the investee. So which is again a positive approach by RBI in this regard, looking at the commercial complexities and other stuffs. Now, the rule requires or envisages that full value of the security is to be issued upfront. However, in real life, this may not be commercially viable as the investee entity may not be willing to issue shares or part with the securities upfront while receiving only a partial payment for that purpose. So this is something which we'll have to factor in while structuring the transactions.
Right.
Are there any views from you on this?
Yeah, so also Pankaj, that there's some clarity. While the banking side is clear that you could create a bank account for this purpose, but an escrow in itself is something that we may need more clarity on. So for example, can the shares be parked in an escrow, and does that sufficiently meet the condition of having got the share? Could be a potential solution, but it needs more clarity from Reserve Bank's perspective. Again, the good part is you could have an incentive payout or punish the investee for not performing, or the promoter of the investee for not getting the value that originally was agreed. So to that extent, a price adjustment also seems to be a possibility. Of course, within the valuation norms that have crept in. So that is also a critical change that RBI has now insisting on value assessments, although not by itself, but by through an AD authorized dealers mechanism of how value should be perceived. So this can be, hopefully it should be consistent, but can lead to some inconsistencies across banks.
Great. Thank you for that. We'll move on to the next point. Sridhar, I'll again come to you, that the scope of acquisition by way of swap. Now that has been enlarged. So now swap of securities is also permitted as compared to the earlier limitation on swap of shares. So how will it have an impact? What is the term securities? What all will it encompass? Because I don't think there's a specific definition for it in the OI regulations as I see it. So are there more investment opportunities, more confusion? So Sridhar, your views.
Firstly, RBI's drafting has been welcome, I would say, because they haven't defined it. So not having defined it creates the possibility to interpret it through delegated rules or delegated reading. Hopefully RBI will be consistent across time, and that is the important part.
You are
there.
happy because there are more professional assignment opportunities.
Also, if RBI were to be consistent in the understanding of security, it will open up quite a few possibilities, Riaz. So let me explain that. That, for example, now, because the term security is not defined, it could mean shares or securities of an Indian company or a foreign company. So you have a two-way reading that is possible. So swap on both ways seems to be ticking the box. The second is, as you rightly pointed out, it could also mean debt instruments or debentures or other instruments which fall within the meaning of a definition of securities under the Securities Contract Regulation Act. So to that extent, again, a fairly liberal reading could be kind of played out. A possibility, just throwing this up, but I don't think anybody has done this, but a reading suggests that even an outbound swap is possible, which means that a resident giving up his shares in an Indian company in exchange for shares of a foreign company. So that also seems to have opened up, because the swap of securities in theory includes both ways. While the earlier reading was only inbound swaps were permitted, where a non-resident was given the share of an Indian company. So the Indian company was acquiring an overseas investment with a swap of its shares. So an Indian company's shares were issued. So a swap on both sides seems to be opening up in possibility, but this needs a fair bit of debate to see if this is the intent. The other is the possibility to issue an instrument like a debenture or a redeemable preference share to a non-resident in lieu of a swap for acquiring the foreign company shares. So the Indian company would then acquire the foreign company, and instead of paying in cash, the Indian company would create what would construe an ECB to be paid later. And under earlier regime also, an ECB proceed could have been used for acquiring a foreign company. Now, harmoniously, this is not an ECB proceed, but the ECB is getting created while the transaction is happening. So hopefully, at an intent level, RBI needs to clarify that such an ECB is possible. And of course, the ECB regulations in themselves should also facilitate this. So to that extent, more clarity needed on this. But for resident individuals, there is still a limitation. So there's, interestingly, resident individuals can swap their shares only by way of merger, demerger, amalgamation, or liquidation. So to that extent, there are fretters on what an individual could swap his investment against, and a simpliciter swap outside of these schemes, or under bankruptcy law or any of the other laws are not seemingly covered in this situation. So to that extent, a resident individual seems to be disadvantaged in this position. And loud thinking here that a company located in an IFSC is technically able to merge into a domestic company, because both are Indian companies under Indian company law and tax law. But this could potentially trigger RBI's cross-border merger regulations also. So that clarity is also needed. But there is again the round tripping issue as well there, which needs to be addressed, but certainly seems to be opening up some more possibilities in the way swap is read.
No, I think these changes will definitely create a lot more structuring opportunities. Even if you talk about a Singapore entity which does not allow outbound merger through an IFSC, you could possibly do it. Or so there are a lot more opportunities, but I think some clarifications will need to be sought before one can go whole hog into those opportunities. But clearly a move in the right direction, so which is going to help us. Right. Pankaj, we still have, I think, 5 minutes more. So the new regulations bring in clarity for the net worth definition. What are your thoughts on that?
So the meaning of net worth and whether securities premium can be included for the purpose of computing the amount of net worth was always a matter of debate. And in real life, we have seen ADs are taking divergent views while interpreting the meaning of net worth for this purpose. Now, with the specific meaning assigned to it and the term has been aligned with the meaning given under the Companies Act, may help in settle down this debate once and for all. And there will be a consistent views coming from the entire banking sector on this matter. However, at the same time, RBI has also brought in some restriction when we are looking at the net worth. Earlier, it was possible to include the net worth of subsidiary companies while computing the window for overseas or financial commitment. Now, going forward, net worth of subsidiary companies will not be included within the or for the purpose of computation of net worth, and it will be only limited to the net worth of one holding company. Now, this essentially means that we'll have to wait and watch what will happen to the existing investments which have been grandfathered, and those have used the additional window coming out of the by including the subsidiaries net worth while computing this 400% limit. And maybe RBI will have to once again clarify on this issue. Otherwise, another round of debate will start.
Great. Thank you, Pankaj. I'll try and squeeze in one more important question, Sridhar. What do you think about the rules relating to ESOPs and sweat equity now that have they been eased, or what are the really big changes there?
Yeah, so there is one interpretation that the LRS limit may not apply to stock options, and that's coming through the wording in Rule 3 in Schedule 3, which suggests that it is without limits. They have exactly used the word without limits. Now, the term without limit can be used to describe number of shares or percentage of shares, or it could describe value. So if it describes value, then it seems to suggest that the $250,000 limit does not apply to shares that are issued through an ESOP window, and an actual remittance of an amount higher than that seems to be possible as long as it is fitting within the stock option sweat equity plan of that company, particularly stock option plan. If that were the intent, then this is a significant move to set a different limit for individuals who want to exercise shares that are offered through ESOPs. That's one big point. And the second is the window around the cashless ESOP, which was allowing any person in resident, whether employee or not, to get the shares of a foreign company under a cashless stock option plan. That window has gone out, which means that everything then falls within the stock option plan, which must necessarily be for employees as long as it is stock option. Of course, there is a separate window which allows capitalization of receivables. So if you had provided services and you have a receivable, you potentially can capitalize that again within the $250,000 limit. But the real change seems to be this without interpretation of the word without limit, Riaz.
No, great. Thanks, Sridhar, for this. Overall, we have a lot more questions, but we are unfortunately running out of time. What we can take away from the discussions today are that while all these changes are positive changes, could help in restructuring, help in global business rearrangements also in a big way, clarity is really required from the RBI on a number of issues. Otherwise, the purpose may be defeated, and we might have more disputes rather than reducing these disputes. We also have a lot of questions from in the Q&A box, but I think now that we are exactly on time, we will get back with our answers to each of the queries. I can just thank you both, Sridhar and Pankaj, for your very, very lucid and informed answers. And I thank all the participants for taking out the time and attending this. Thank you very much.
Thank you.
Thank you.